Ladies and gentlemen, welcome to the final guest lecture of the CIL eAcademy. Today we have Judge Liesbeth Lijnzaad speaking about Travaux Préparatoires today, some reflections on Travaux Préparatoires in contemporary international practice. Allow me to now hand you over to our moderator, co-director of the eAcademy, Professor Patricia Galvao-Teles.
Thank you so much, Zoe, and greetings to all and a warm welcome to Judge Liesbeth Lijnzaad. It's really a pleasure to have you with us today for what is the last guest lecture of the CIL eAcademy. After 15 weeks, we're finally coming to the end. And so this is, of course, a special moment, and we are so happy to have you, Liesbeth, with us for a talk on a very intriguing and interesting topic of Travaux Préparatoires today. I think we will learn a lot from you and maybe think about something that we are not aware and that we're not thinking of at the moment. Let me just briefly introduce you to Judge Lijnzaad. We will do as usual. Judge Lijnzaad will do a presentation, and then there will be ample time for questions, and we very much encourage you to take the opportunity to ask questions and make comments, and do it by the chat or in live questions. And also you're very welcome to turn on your videos so that we'll see you for a last time in these guest lectures. So Judge Lijnzaad has been very active, not only academic, but practitioner in the field of international law. And again, it's been our trademark in our guest lectures to have somebody who combines both a solid academic background and with a strong practical experience. So currently, she's a judge at ITLOS, at the International Tribunal of the Law of the Sea, and this is the case since 2017. And at the moment, she's also professor of practice of international law at the Maastricht University in the Netherlands. Before joining ITLOS, Judge Lijnzaad was a legal advisor in the Netherlands Ministry of Foreign Affairs for over 10 years, and that's where we met back, I don't know exactly when, but in meetings in New York and in Brussels and Strasbourg. And as head of the legal department in the Ministry of Foreign Affairs, Judge Lijnzaad has acted as agent for Netherlands in cases before the International Court of Justice, the International Tribunal for the Law of the Sea, and the International Criminal Court. She's also a member of the Permanent Court of Arbitration and a member of the Sanremo Institute of International Humanitarian Law. So we're very happy on behalf of the CIL eAcademy, of Nilofer and myself and all the participants to welcome you, Judge Lijnzaad, and we're very grateful that you have accepted our invitation, and we are eager to listen to your lecture. So the virtual floor is all yours, and then we will come back with questions for you at the end. Thank you so much, Liesbeth.
Thank you very much for that introduction. Let me start sharing my screen so that we can start. Thank you very much for the introduction, Patricia. It's a pleasure for me to be with you today. For me, it's early in the morning. I guess it's in the afternoon in Singapore, but people are here from everywhere, which I think is interesting in itself. And it's quite an achievement from my colleagues in Singapore to have attracted that many participants. I hope everybody can hear me. I'm not sure if everybody can see me, but if you can hear me and can see the screen with my presentation, I think we're ready to go. You will all get a copy of the presentation once I am done today. I'm going to talk to you about what is known as Travaux Préparatoires. Even if this is a lecture in English, I will use the French Travaux Préparatoires because that is how preparatory works of treaties, the preparatory works dealing with the drafting of treaties are commonly referred to travaux. That literally means in French work, preparatory work, but travaux itself means work. Now, before I start, I have to mention that I'm going to talk about what is essentially ongoing research. I'm going to talk to you about something that I find fascinating. So I hope for a lot of clever comments when we get to the question and answers, because your comments and your questions, I'm sure, will also be helpful for my thinking as I work on an article about this subject. Now, this question for me starts with a reflection, and I think a reflection when I started out as a judge as well, a reflection about which sources do we rely on as academics, as judges, as practitioners. Which sources do we rely on in the sense of where do we find the information on which we base our legal reasoning? Now, of course, coming from with a background as a practitioner, being the legal advisor to the Netherlands Minister of Foreign Affairs, that also means that I happen to have negotiated quite a number of treaties. So that's the behind the scenes approach that I also bring to this subject. Now, without further ado, just to get us started, oh dear, where is the thing for the slides? Where? Ah, yeah, sorry, I'm pushing the wrong button. Right, as a starter, you will all know, I hope, and I certainly hope you've seen these texts before. In the Vienna Convention on the Law of Treaties, we essentially have two key articles that give us the general rules with respect to the interpretation of treaties. And the chief rule is interpretation. A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. And then from that first paragraph of Article 31, the provision continues talking about what exactly the context is and what this means for the interpretation. This is the general rule, and we're not going to talk about the general rule. The general rule is the starting point in every interpretation exercise. What we are going to talk about today is Article 32, which reads, recourse may be had to supplementary means of interpretation, including the preparatory work, the Travaux Préparatoires, and the circumstances of its conclusion. So the circumstances of the conclusion of that treaty in order to, and it gives you the two options, in order to confirm the meaning resulting from the application of Article 31. So that really means to check if you, the result you have achieved, the result you have come to on the basis of your interpretation using the rules in Article 31. So you may use the preparatory work to confirm that you did get it right on the basis of Article 31, or to determine the meaning of that, of that part of the treaty when the interpretation on the basis of Article 31 leaves the meaning ambiguous or obscure. So essentially that is saying you didn't quite get to an answer that is understandable on the basis of Article 31, or on the basis of Article 31, you have come to a result that is manifestly absurd or unreasonable. So either you look to Article 32 to confirm the results that you've achieved under Article 31, or if you are really in trouble, you have ended up with a conclusion that is ambiguous or obscure, or it's even worse, it is manifestly absurd or unreasonable. In those situations, you look at the preparatory work as Article 32 explain to us. And what it does is, this is striving for clarity. Striving for clarity as to, well, what on earth did they intend when they wrote this particular provision? What does it mean? And I should say that this provision, the very idea of having a look at the drafting history of a treaty is ingrained in the minds of international lawyers. Everybody is raised, I would almost say, with the idea that travaux préparatoires are of great importance. So why is that the case? Travaux préparatoires, preparatory work, is a tool for treaty interpretation when your first tool has failed. So the fairly down-to-earth, simple rules in Article 31 have not led to anything that you could really use if you are in a situation where you have not been able to confirm the meaning that you have arrived at in Article 31. So you need an additional tool to figure out what is the meaning of a particular provision. And what this does is travaux préparatoires are relevant because they presumably tell us what happened during negotiations. And why do we need that? We need that because we were not there during the negotiations. I'm sorry. The negotiations take place in a certain period of time. They would normally take place somewhere where not everybody has access to the negotiations, and they will take place somewhere far from home. So particularly as the treaty grows older, there may be a few people who were there when the treaty was negotiated, but over time, that amount of people, the number of those people diminishes. So we are very often called to interpret treaties that we have not drafted ourselves. We were not there. So the idea is that if we have access to the records of those negotiations, those records are going to tell us what was intended. Here you are with a provision that is difficult to follow. You just, sometimes you, and I will tell you further on how that happens, but you will sometimes find provisions that are not straightforward. They seem to say something, but you just haven't got a clue. And then the idea is we have records of those negotiations. And if only we study those records, we will find out what was intended. So that brings me to two crucial questions that will be at the heart of my talk today. The one is, who creates the travaux and who uses the travaux? Probably the simple answer is, who creates the travaux? Well, states when they negotiate, and who uses travaux? Well, states when they interpret. That was the simple answer. So who creates travaux in reality? Well, that depends on what you say is creating the travaux préparatoires. The content of the travaux, so what went on during the negotiations is, of course, everything that was said during negotiations. State A will make a point and State B will disagree, and State C may offer some sort of compromise solution. In negotiations, the views go back and forth between the various states that are participating, who are representing their own interests, of course, and interests could be all kinds of interests: political interests, economical interests, but also political ambitions, such as we want to bring carbon pollution down, and we want to formulate a rule that effectively will assist us in bringing pollution down. Whereas others in the same negotiations may feel that, you know, it's a good idea, all this limitation of pollution by carbon and other pollutants, but frankly, we have an interest in keeping the economy going, so, you know, let's not be too hasty. All these different views, all these different expressions of opinions, of interests during the negotiations can be written down. There will be sometimes, very often in the past, there will be reports of which delegation said what during the negotiation. And then eventually, as the negotiation goes through different stages, this will lead to a text that will be adopted in the end. And the way that works is that in the end, everybody is a little unhappy with the text, but the overarching idea is that we are happy that we have come to a conclusion, and that as many states as possible are going to be bound by this particular text. So it is states who create treaties, it is states that create Travaux Préparatoires, because they are a reflection of what it is that took place during negotiations. Another way of looking at this question of who creates Travaux Préparatoires is, of course, who writes it all down? Who ensures that there are reports? And there the answer is, well, very often it is international organizations who will produce daily reports. They may be producing summary records. They may be producing procès-verbaux. When it gets serious, it's in French, of course, in international law. And those are all the types of reports that some years later, academics may want to publish. So this is creating the travaux in another sense. Someone, an organization, an academic, a publisher, will go through the trouble of publishing these materials that are then available for anyone, any academic, any lawyer engaged in a particular case, and they will be accessible and they can be referred to under the rules in Article 32. That brings me to the other question: who uses travaux? Well, travaux, as I already mentioned, they are a set of it's a set of information that is available for treaty interpretation. And so apart from, of course, academics doing research, but treaty interpretation is of crucial importance to governments. If there is any confusion about what a treaty precisely says, you will want to know what is precisely intended with a certain obligation in a treaty. Particularly so if another state has a different reading. You will want to know who is having the precise and proper interpretation of that provision. As I said, particularly so if we're looking at a treaty that has been negotiated some time ago, and where all the negotiators have already gone into retirement or are no longer with us. Another group of people who clearly needs access to well-organized travaux préparatoires are the judges in court cases, as well as the agents and councils of the states that are participating in those cases. Now, I would suggest to you that when in academic work on the law of treaties, when we speak about the use of travaux, it is mostly about this second question, who uses travaux? And of course, that is for academics to tell us, did they get it right? Do we agree with the analysis made by judges in particular cases who draw conclusions from the Travaux Préparatoires of a particular treaty? Now, just some general points, and I'm sure that if you have already taken the subject of the law of treaties, you will know all about this. Interpretation, as we all know, is a human activity. It's not a precise science. We suppose that we will understand treaty provisions as they are because we take it that the drafters have tried to formulate the rights and obligations in a treaty in a precise manner. At least that's what law professors always tell law students. Be precise, think about the language, and try to ensure that what you're saying is not fuzzy, but is precise. However, and this is where the practice comes in, compromises are made. Political solutions must be found, and a text may lose its clarity and coherence during negotiations. And when I still worked in government, particularly chairing negotiations of difficult documents, what happens is not only compromises must be made, but don't forget the terrible Thursday night negotiations towards the end of the week, where at 4:20 in the morning, all the coffee has gone, the coffee machine is empty, and there are no chocolates left. A lack of precision will arise by the time everybody gets extremely tired. But because we cannot leave without a result, we just keep going. But it is obvious that at 4 o'clock in the morning, nobody in the room is very sharp anymore. Anyway, interpretation is an activity we take for granted. It's a bit matter of fact. We can all read, so we must be able to understand a provision. And that is generally true unless we are forced to look at the detail of a particularly relevant provision. Of course, we can all read, but at a certain point, you may be in a situation where the words do not make sense anymore. Now, let's move on. I'm now going to go into the detail of Article 32 of the Vienna Convention. The interesting thing is, if you look at the text of Article 32, it's an open category. The supplementary means of interpretation are an open category. Recourse may be had to supplementary means of interpretation, including the preparatory work of the treaty. So it's an open category, and it will very much depend on what kind of document is presented for judges to evaluate in a court case in order to determine whether or not that is a document that is relevant as Travaux Préparatoires. Now, normally we look at things like the diplomatic history of a treaty, the official records when they exist of the negotiations, the draft texts that were proposed during negotiations. So a text will go through a number of iterations during negotiations, and that development may demonstrate something about the way in which the intentions were formulated during negotiations. Statements by state representatives during debates in the negotiations, diplomatic exchanges or notes may be relevant, but then those would not normally be in the public, so they would have to be shared for the purposes of interpretation. And things like uncontested interpretations of the text by the president of a drafting committee. All of that may count as relevant preparatory work. There is more discussion about perhaps the relevance of the work of the International Law Commission, of certain special rapporteurs within the UN, committees of experts and of similar body. But there is, as I said, discussion about the appropriateness of using those sources as travaux préparatoires. They may be historical background and may really be more related to either the context of the treaty, as it is referred to in Article 31, or the circumstances of the conclusion, which is the other category mentioned in Article 32. Now, travaux, and this is, of course, a very badly legible slide. The text in the back is from the Travaux Préparatoires of the Covenant on Civil and Political Rights, where Professor Boshout tried to, by using different letter types, to give us an idea about how the text developed, the different stages of development of the treaty text while it was being negotiated. Now, I should warn you, if you want to have a look at Travaux Préparatoires, they are not easy to read. For the editor, that brings all kinds of organizational questions. What are you going to do? Are you going to organize the information by session, by article? There is a lot of reflection to be done as to how you want to demonstrate the drafting history of a provision. And in that process, the Travaux Préparatoires go from what I tend to say, the plain, uncut, in movie terms, the uncut Travaux Préparatoires, to the edited cut, the director's cut of the Travaux. Choices are being made by the person who is producing the Travaux Préparatoires. And maybe that's a question from me to the audience. How many of you are really using the original texts today? Do you actually go back to the papers that were produced during negotiations, or do you instead use one of those lovely publications of Travaux Préparatoires? For those of you who seek to take up a job like that, to produce Travaux Préparatoires, be careful. It takes a lot of time, and it doesn't bring much academic glory. It's extremely helpful that those publications exist, but it's not going to make you the star of the day. It's not very, I think it's undervalued work, as it were. Now, at one point, as we started to move ahead, this was the way to publish the Travaux Préparatoires of the whole of the Law of the Sea Conference from 1968 all the way to 1994. And it was a treasure to have these two CDs. Of course, these days we're less impressed with that. And this is an example of the edited Travaux, where you do get the information, but an editor is starting to explain to you, look at this source, look at that source, and is more or less providing a travel guide through this pile of information that is the Travaux Préparatoires. Now, to recap, what are the preparatory works? We can only say preparatory work, of course, if it is related to documents that exist before the adoption of the treaty, because we're looking for the intention of the drafters. And in doing so, the documents that are closer to the adoption of the treaty text are more convincing than the older documents. The documents that are nearer to the final date will be seen as having more of the common intention of parties as to what it was that they wanted to express in the treaty and in the particular provision that you want to interpret. We're looking for information in writing, and we are also looking for information that is not confidential. It has to be information that was relevant to all the parties in those negotiations, not just a particular group of friends or allies. The Travaux clearly inform us about the evolution of the text and the evolution of the provisions during the negotiations. So be careful. Your opponent may rely on a particular document, but it is important to see that document in the whole chain of events, all the steps in the negotiations that led to the final formulation of the treaty. Now, then again, this raises another interesting problem. What if the treaty was negotiated by a particular number of states, and the state that you are represented was not there, perhaps because it didn't exist at that time? So, and that state may have joined the treaty later on, may have become a party later on. But by joining the treaty at a later stage, by accepting the treaty and accepting to become bound, does that mean that that state more or less inherits the Travaux Préparatoires? Is it bound by the Travaux Préparatoires? Or this obviously creates a bit of a problem. They were not there, and they have not been able to push their own interpretation and their own wishes with respect to that treaty during the negotiations because they were not there. Now, are Travaux, another question, are Travaux necessarily conclusive? Are they trustworthy? You will find that Travaux are often a huge collection of individual opinions of states, and not everything is equally relevant to the final text. And then the final part of the negotiations, this is where very often accidents happen, the last minute negotiations, the sleepless final night, all of that is likely not to be very well documented because we want to do the final deal. And we're not going to do that in the plenary. We're going to do that in the corridors. We're going to talk to a number of chief negotiators. And we may be doing that in a corner just amongst ourselves, and it's not going to be reported. Apart from, of course, the closed room discussions that tend to take place from time to time. Now, it's important for me to point out the Travaux create a kind of, I've called it a time warp. Article 32 is a retrospective provision. So interpretation today, if we follow Article 32, interpretation today relies on drafting history, and the history is static. It can no longer be changed. The idea is that the past, so the time of the negotiations, will help interpretation for the present. And so the reliance on Travaux Préparatoires ties us to the past. And that makes me wonder, is there a point in time where we can say that Travaux recede into the background and become a part of the history of the treaty rather than an aid to interpretation? I think this is an important question and one that perhaps we can discuss in a minute. And to give you an example, if you have gone through the article by Gardner, he talks about this Hosaka case, which is before the American judiciary. And the case, if you go through the footnote, it's a case in 2002, and it talks about the Travaux Préparatoires of the 1929 Warsaw Convention. That's a long time ago. And if you look at those dates, it feels very odd. It feels very odd. And William Chambers, who has written an interesting piece about the Travaux Préparatoires of human rights treaties, he says, well, the Travaux focus on the views of the drafters. That's my point about the history. But he says, well, what about things like the dynamic interpretation of human rights treaties, or the concept of the treaty as a living treaty? And that is much more emphasizing that treaties take on a life of their own sometimes. Of course, not every treaty, ordinary bilateral treaty probably doesn't, but a number of those major treaties take on a life of their own. And if we interpret them, should we really be going back to the time when they were drafted? Or is perhaps a reliance on travaux préparatoires not a good idea in those cases? And it's getting worse, dear friends. I would note that increasingly formal records of debates and so of the drafting activities, the travaux, are absent. Reporting is extremely costly, and it depends these days on the availability of funding. Also, translation is costly. And remember, the United Nations works in 6 languages. I'm thinking that perhaps the ILC is one of the last bodies to produce its own travaux préparatoires, apart from the question whether or not, technically speaking, these are travaux préparatoires. So what we now see is that increasingly NGOs are reporting at UN meetings. And very often you see, particularly in the field of environmental issues, the Earth Negotiations Bulletin doing the reporting, and that is a bulletin, an activity by an NGO. So on a number of major contemporary projects, such as the implementing agreement on marine biodiversity beyond national jurisdiction, there is no formal reporting, no more summary records. So no sources to go back to once we have the treaty and we are looking for detailed interpretation. The only thing we have is reporting by Earth Negotiations Bulletin. The same thing for the International Seabed Authority in Jamaica, which is currently working on the mining code for the exploitation, the exploitation of polymetallic nodules. This is going to be important secondary regulation for deep seabed mining. The Seabed Authority used to issue press releases with a lot of substantive content, and now they have also moved to Earth Negotiations Bulletin. Another major project of the United Nations these days, the Treaty on Business and Human Rights. No formal reporting, only reporting by NGOs. Now, I think in part, all of this, it's driven by costs. It's also driven by things like the thought that we can work paperless. So the UN has moved on and now uses this paper smart system, which, well, there's a whole story about that, I think, which in part was also stimulated by the fact that the printing office in the UN was completely drowned in the aftermath of Hurricane Sandy in 2012. So is this an understandable development? Well, maybe it's an understandable development. Producing reports is very expensive. Translations within the UN system are also very expensive, but it raises the question, who is responsible for the reporting? Maybe this is a generational issue. Maybe it's I'm old and you are young and you're not that worried. But my question, my fundamental question is, what does this mean for interpretation of treaty provision, and what does this mean for the role of Article 32 of the Vienna Convention? Now, that going back to these two questions I raised earlier. I think the true question is, well, who creates these travaux? States, when negotiating treaties, they are produced by international organizations, we thought, but these days they are produced by NGOs who publish reporting. And there are sometimes complaints about the bias in reporting by NGOs. The interesting thing is when you look at what academics say about Travaux Préparatoires, it's always about, well, did we draw the right conclusions from Travaux Préparatoires? But the starting point is that Travaux Préparatoires will always mysteriously be available. I'm not so sure about that, and I wonder what that is going to mean in the future, because we still will have to interpret treaty provisions. Now, Gardner, in his big book on treaty interpretation, he writes, many a modern treaty text has been worked up under the aegis of an international organization. So we're all negotiating at the UN, that's what he says, saying there, where the records are likely to be well maintained and disseminated. That is what he says in 2015. I am worried that that is perhaps no longer true. Thank you for your attention.
Thank you so much, Judge Lijnzaad, for this excellent presentation that draws our attention to a problem that perhaps we were not so aware of. And I think that it really results from your perspective as not only an academic concern with these things, but very clearly from somebody who's had a governmental experience and knows what it is negotiating a treaty and how treaties are negotiated, and also your role now as a judge in an international court, where you see from the other side also the importance of having the good records. I see that Robert has asked to ask a question, so I'm very happy to pass the floor to Robert for a live question.
Thank you very much. And Judge Lijnzaad, thank you very much for this presentation. This is very important to me. So lest you think that this is a topic that is of interest to you and not to others, I think that's not the case. My question is this. So thank you very much for the discussion. Very practically speaking, and as you've mentioned, there are obviously increasing difficulties in getting a hold of the Travaux Préparatoires. Would you mind to speak to the general strategies for obtaining and locating Travaux Préparatoires, perhaps in the context of bilateral treaties where you may not have a centrally located repository of those sorts of documents available? Thank you.
Yes, well, with respect to bilateral treaties, I'm not sure. I suspect it very much depends on how much at the bottom line of the issue of the absence of Travaux Préparatoires, I think, is money. It's all about money. I think that what matters a lot is the practice of states and how they understand the importance of Travaux Préparatoires. So it is because the fact that you go through the trouble of producing a collection of Travaux Préparatoires means that you need to be aware that, who knows, at some point in time you may need them. And the odds are, of course, that you will publish the travaux that you don't need, whereas you get into a situation where, oh dear, let's see if the archive person still has the box that has our notes from the negotiations way back when, including, and then you get into all sorts of other problems. So I guess, yes, in part it's about money, in part it's also about knowing what it is you're doing. international lawyers will be able to tell the archive person or the library person in the ministry, you have to keep all these documents related to these negotiations because they are important. And I have seen this in the ministry in the Netherlands, and then the ministry moves and we have all these nonsense boxes of very old negotiations. But you see, we have the treaty now. Why keep the boxes with all the negotiation stuff? So that gets easily thrown out at your peril. So I'm now getting questions from my former colleagues. Well, why did you put this in the treaty? And then I'm thinking, hey, I left, it's up to you now. Why did I put that in? Well, because it was a wise idea at the time. Now, the question was about a relatively recent treaty, so I remembered. But the point is that if you publish, if you get yourself organized and properly keep the documents, you are building in safeguards that you may need. Now, I think there are two other aspects there. The one is that, of course, in a bilateral negotiation, I would say that I have not seen many documents published about bilateral negotiations if they were about relatively, let's say, ordinary things. The cases that we see, for instance, IJzeren Rijn, the Iron Rhine arbitration, that was a major issue, of course. This was the state falling apart, the Netherlands, Belgium splitting from the Netherlands. Those were major steps. So it stands to reason that that is well kept because it is, people know at the time this is of historical relevance. But something like a bit with the neighbors or with a faraway country. Well, you know, the approach to those treaties might be, well, you know, it's a bilateral investment treaty. Once you've seen one, you've seen them all, which is of course not true. But why would we be doing an organized travaux version of the stuff from the negotiations when we think, well, you know, there's a relatively limited scope, we don't have major trade with that particular country, things like that. The other perspective, and I think this is where perhaps the importance of Travaux Préparatoires is sometimes underestimated, is when we are talking about treaties that create direct rights for our citizens, where it's not just whether the states amongst themselves can agree on what it is that the provision was meant to say, but also the question, well, if as a citizen, as a company or as an individual, I am entitled to particular rights under that treaty. Am I a company? Is this type of investment a type of investment that must be understood to be protected by the bilateral investment treaty? Then I would think, well, it would make sense for those who have a direct interest to have access to those documents. And these days, I would say that goes through different legislation, the access to public information type of legislation, where you bring a case and say, well, I want to have access to all the boxes that keep the stuff that is about the negotiation of that treaty, if they still exist. So I'm not sure if that's an answer, but there you go.
Most assuredly did. But may I ask a follow-up question? Is that possible?
Sure, go ahead.
So on a related note, and obviously not to be rude to any particular state, what I'm wondering is this: have you ever seen a situation in which Travaux Préparatoires appear after a dispute has developed, that it is, as you've mentioned, found in states' reserves, let's say, and maybe there are questions of authenticity, so that if, for example, Travaux Préparatoires were favorable to a state's interpretation of a given treaty, then how would that play out as far as authenticating those documents, given the challenges that you've mentioned with reporting today? Thank you.
Well, to answer your question, the simple question is no, I've never seen that. If you read literature about Travaux Préparatoires, then one of the crucial issues is they should be Travaux shouldn't be non-contentious. So we can only talk about a document that both of us know and that both of us accept as relevant. What the document, whether that helps in clarifying the meaning of that particular document for the understanding of that particularly complex, fuzzy provision, that's a different thing. So, and this is also why somewhere in the slides is more or less a list of the types of documents that can go in. The documents that we can speak about are documents that should have been available to all during the negotiations. Now, the negotiations may have been confidential, so we did not have all the NGOs in the public gallery because that is not necessarily helpful for negotiations. But of course, it would be easy if I could rely on my favorite document and you could rely on your favorite document, but then Travaux don't solve anything. So what, in a case I would suggest that you bring, if you have one of those fuzzy provisions, you would, from my perspective as a judge, you would do well to demonstrate the development of that provision over time. And what remains when we don't have the reporting, what remains are the different iterations of the draft text. So if you, for instance, now look at the way in which the BBNJ discussions are going, it starts out with things like the zero draft, in which the chair tries to bring everything together. Now, that text is not meant to be anything like the final text, but it is a way of moving the negotiation forward. This is what the chair has got to do, and the chair knows that she's going to be fired at by many people because you formulated in a way that I don't like. And doing that, in fact, stimulates suggestions. We'll get drafting suggestions. So the next, and sometimes it's the zero draft, sometimes it's the president's proposal or whatever. So, and over time, you will see a number of iterations of that text, and the provision that is fuzzy at the end and got adopted anyway, you can trace it back. And hopefully you will be able to find things like statements from various delegations. This is delegation A says we need to take a left turn, and delegation B says we need to take a right turn. Delegation C says we don't need the provision at all. So this is the ebb and flow of negotiations, I would say. Actually, I liked chairing meetings because you see this movement, not just in the text, but also in the room.
Thank you very much.
Pleasure. Thank you. We have a request from Ahmed from Egypt. Go ahead, Ahmed.
Yeah, Doctor, thank you for your nice presentation and for your these fruitful thoughts. I have a question and a comment. For the question, do you think that the reports of the negotiations which are currently published by the NGOs is a part of the increasing role of the NGOs in general in the international relations stage, which comes on the coast of the government's role in this regard? And my comment also is that the Travaux Préparatoires is important because the treaties after are drafted in certain time, maybe later the circumstances may differ, and which dictates change of a part of the clauses of certain treaty. So this is why the importance of the Travaux Préparatoires comes, as you mentioned in your nice lecture about the human rights. Maybe I draft a certain treaty about human rights in 1920, for example, and then after a while now 2020 is different than 1920. So we need, if we want to change this certain clauses in this treaty, we need to go back again to the Travaux Préparatoires in order to get to know the circumstances that the first treaty has been drafted for. Do you share me this thing? I mean, this way of thinking? Thank you so much.
Thank you. That's an interesting question that you raised. First of all, about the role of NGOs. Let me put it like this. For me, as a lawyer and as a former diplomat, I have always been taught that it is important to make clear what it is you want, to be clear about your aims with a particular treaty and your intentions with the drafting of a particular treaty text, and to make sure it is somewhere on the record. So you will produce a non-paper, or you will produce a statement. Of course, for the Netherlands, very often that is together with the European Union. And this is important because you want to steer the debate. That's why we're negotiating. You want to steer the debate in a direction that is favorable to your interests, whatever the interests are. And mind you, interests are not a dirty thing. We participate in the international legal order because we want to achieve something. Whether it is we want to fight pollution, whether it is because we want to bring human rights closer to everybody. So interests go in many different ways. So I am happy with NGOs taking over the reporting, because that means that there is reporting. As a lawyer, I find this somewhat problematic, because if you look at the notions of Travaux Préparatoires, it is information about the position of states and how states themselves see their position. We now have ended up with a situation in which well-informed NGOs are going to state, this is what state A thinks is important. I would rather, in 20 years' time, have access to what state A itself said, rather than the transcription by the helpful NGO about what state A intended. I don't know if they get it right. The NGO, I don't think, can take responsibility for the reporting at international level. But then there is nobody who does that anymore. Now, various international organizations tell me, because I've been asking people, they tell me, oh yes, but we keep audio records. But then you'd have to go there, make sure that you find the right MP3 file or the right CD. I showed you the CD with the text, or even the cassette. In Jamaica, they said, oh yes, but we have cassettes of the early meetings of the Assembly of the Seabed Authority. I'm not sure about you, but it's been quite a while since I used a cassette recorder. So this is a problem I see. Now, as to changes, sorry for that. As to changes in the law, I think you are touching on a very important point. We have formal rules about changing treaties. We have rules about amendments. Treaties themselves normally have procedures for that. We have rules in the Vienna Convention. So technically speaking, changing a treaty is possible, technically speaking. Politically speaking, it may be very difficult. This is an ongoing debate. For instance, in the laws of armed conflict, there are many rules that are dated, I think. But if we would open the Geneva Conventions and say, well, let's revise them, the warning, the overwhelming warning is, don't even think about it. Because if you say, let's revise, and I'm bringing the good plans, but there is going to be somebody at the table who is bringing the bad plans that are not improving protection, but rather reducing protection. So there is, for me, this is a fascinating question. How do you deal with change when you don't want to use your formal procedures? Same thing for the Law of the Sea Convention. It has perfectly organized provisions on amendments. That's not the problem. The problem is that we don't think it's a great idea. Remember, Law of the Sea Convention is a construction that relies on a multitude of compromises. So if I, years later, this was all negotiated all the way up to, let's say, 1994. So 25 years later, I've never been there at the third conference. So I don't quite remember what the trade-off was between this article and the other article. So if I really suggest we must be changing this article because I've got a much better idea, you don't know what's going to move. So there is, I think, we are in a time of a certain inertia. We have all the rules there in any domain to amend treaties. But there are so many hurdles, and those hurdles, perhaps they're not even legal. They're more of a legal and political nature. We can change any treaty, not a problem. But we won't, because international law has this huge political element there as well, and we don't want to ruin the system. So you see that we're moving to some informal norm setting, and I think that's particularly visible in the laws of armed conflict, where and you know, change is very often driven by technological change. We have new tools, we have new arms, so we need rules that will cater for those new tools. Look at the development of law related to cyber warfare. None of that is in a treaty yet. And we can't really, it's not a good proposition to say, well, you know, let's start amending the 4th Geneva Convention to protect civilians against the threat of cyber warfare. I mean, I agree that we have to be clear about how that protection is organized. Now, that's not the same thing as saying, let's amend something.
Thanks, Liesbeth. I think we're just a little bit over time, but if you would allow one very last question from Ankit from India. Go ahead, Ankit. That will be the last question.
Thank you for allowing me to take a question, Professor, Doctor. Thank you so much for your time and lecture. I think just to comment, it's all a political gamble at the end of the day, which treaty you can amend and which you cannot. I do have my, and maybe this echoes whatever you said in your lecture. I would like to refer to Jan Klever's article which he published in the Cambridge University Press. And he discusses the Vienna Convention on the Law of the Treaties, and now specifically Article 32 and 31. In 31.2 it says that the Vienna Convention, in the quote, Travaux Préparatoires do not even qualify as part of a treaty's context. Yet clearly you see the Vienna Convention envisages but a very limited role for a treaty's preparatory works. Yet most international lawyers almost automatically include a discussion of a preparatory works in the legal arguments, and when consider it too vital to do so. As an argument without paying due regard to a treaty's drafting history is an incomplete argument. End quote. So, as a not as a professor but as a judge, how much importance would you attach to something like this, knowing the historical significance and the legal impact it has on the drafting? That's my question. Thank you.
Thank you. Well, incidentally, Jan Klefner and I studied together, although he tends to be seen as a Finn, but he's actually Dutch. Well, you know, there is something interesting. I mentioned to you that as a lawyer working for the government, we always had in the back of our minds the importance to think about about the proper representation of your view and the reasons for your view, the reasons for asking for a particular word. I don't know, it may seem as though negotiations are about the grand ideas. In fact, I think they're very often about wordsmithing. And you can spend endless time about, I want this word out because my word is much better. And this is because you think that my word is more or less the same as your word, but it is much larger, or just it is much tighter. Well, things like that. What I find interesting is that in reality, the way I see judges talk about interpretation, there is not necessarily a very detailed analysis. Interpretation is given. Both parties come up. One says we have to read the provision like this, and the other side read it like that. And so the judges will be fully aware of the space that there is in these two, and of course these choices. Parties tend to present their views as, the subtitle is more something like, anyone could see that my interpretation is the only possible interpretation. We don't understand how they can be so misguided that they do it another way. So the idea is that the way in which parties present their arguments is that, you know, you could hardly think anything else because I am completely rational. Anyone who reads this provision would read it as I do. In determining which way they go, I don't think that judges necessarily stop at did we look at all the steps in Article 31? And did we determine that something is completely incomprehensible that then takes us to Article 32? Unless rare, the rare situation, I think this is the Qatar-Bahrain situation that was referred to also in the article by Gardner. It is rare that you see something like that. That interpretation, I guess, it is not very often a specific step that judges take when they can prevent to do so. And this is also, I think, it also goes to the question whether or not 31 and 32 of the Vienna Convention, they are described as separate steps. First, you try everything you have in Article 31. If that doesn't bring a solution, then you move to Article 32. I think it is very rare to see it like that. What you will see also in pleadings, in the written pleadings, and also in what the agent and counsel come to tell us in court, you will see that the way the interpretation of a provision is presented is, first of all, the argument is, this is the only logical way to read the rule. This is sort of Article 31. And then there might be sometimes an argument, well, and you know, this is also how it was meant to be during negotiations, which is a shadow of Article 32. It is, you rarely see a counsel saying, well, the steps in 31 are 1, 2, 3, 4, and then we still don't understand, so we look at 32. And this is because I think that this tradition of keeping in mind that you have to point out what it is you want and why it is you want that, as a sort of a second nature for government lawyers, that I don't know, it has become absorbed. So I think 32 and 31 in practice, are taken to be as a continuum. It's not a list that you have to check, but it is the first argument is going to be anyone could see that this is the proper reading. And by the way, this is how it was meant in negotiations.
Thank you so much. I think it's time to end. I have to say that even after 15 weeks, we are departing from our last guest lecture with food for thought, certainly, and with more questions than answers. I'm very grateful, Liesbeth, for you to have pointed our direction to this important issue that maybe it's under the radar for many people. Whereas treaty interpretation, it's something that we all do every day. I mean, academics, government lawyers, judges, it's really the day-to-day activity for international lawyers and academics. So I think we have learned a lot from you today. I'm very grateful for you for having taken the time to be with us today, and also to share your PowerPoint with the participants, which will be done by Zifeng. And I think we have to give you our traditional virtual applause, which is what we can do at this moment. And it was very nice to see you, and thanks again from Nilüfer and myself, and from the Academy, and all the participants who are also virtually clapping.
Thank you very much. Thank you very much. It was lovely to be with you all in Singapore. Pleasure. Thank you. Bye.
Thank you. And Liesbeth, see you around, hopefully in person next time.
In Singapore.
Thank you, Judge Lijnzaad. Thank you, Patricia. So for anyone watching this on the Facebook live stream, the recording of this lecture, as well as all 15 of the distinguished guest speakers in the guest lectures of the eAcademy, are available on the CIL website, as well as our YouTube channel. And do follow us on Facebook, YouTube, Twitter, LinkedIn, and Instagram to find out about CIL's upcoming programs in the new year, starting with the ASEAN Law Academy in February 2021. Thank you, everyone, and goodbye.